Hi, this is this week's Democratic Alliance Labour Report. I'm going to do something slightly different this week, and thank you for tuning in. I appreciate it. If you like what you're hearing, please put it on your Facebook, distribute it to friends, put it on WhatsApp. I'd appreciate that. This is Sunday, the 11th of April, 2021, and like I said, this is our normal weekly Labour Bulletin. The difference I'm going to do this week is I'm going to report on two cases, one dealing with the restraint of trade and another one dealing with the breach of the protocols of COVID-19 at the workplace. The Democratic Alliance has undertaken to keep you informed of all developments in the world of labour, and this is interesting in the sense that these are two court cases that speak enormously to the way our law is starting to treat some of the breaches of employees. The first one, as I said, is a restraint of trade, and the second one is the breach of protocols. So thank you for tuning in. It's Michael Bagram. I'm the Labour spokesperson for the Democratic Alliance, and this is Sunday, the 11th of April, 2021. That first case I spoke about is Interwaste Pty Limited. If anyone's interested, I can send them a copy of it. It's under J197-2021 versus V. Smith. It's an interesting case. It was produced at the end of March 2021, so it's brand new, and it's dealing with the restraint of trade. For everyone that knows what a restraint of trade agreement is, then you'll understand what I'm talking about. But just to explain that a restraint of trade is normally part of your letter of appointment or your contract of employment that is reduced to writing, and that says that you can't work for someone else in breach of that restraint of trade agreement, normally for a period of time and for an area, and it still holds good in South Africa. There's been a lot of rumors abound. Many of the lawyers still think that it's now no longer valid. Restraints are no good in South Africa. Well, they are, and despite the constitution that says that you're entitled to employment, it does restrain you in the breach of you breaking a letter of appointment or a contract of employment. In that particular case, the employee went off to go and work for a competitor. It was strongly fought. The employee argued through his lawyers that in fact the restraint was unreasonable. It was for too large a period, too long a time, and the court looked at it very carefully, and they still said that in South Africa today, the sanctity of contract is still valid, and despite your constitutional rights, an employer can protect their rights by saying that you can't take the trade secrets away, you can't go and steal their customers, their staff, any private information. That's still valid, and in that particular case, the employee was restrained and had to pay the costs of that court case. So it's a very interesting court case. It still underlines the fact that in South Africa today, we are entitled to have restraints of trade. And so employees that have signed it, beware. Your employer might take you to court. For employers, it's still a valid piece of your documentation, and I would still put it in place if you can. Everyone who enters into employment should read their contracts of employment very carefully. So I just wanted to warn you about restraints of trade. The other one is probably a little bit more interesting for everyone, in fact, because as we move into the era now where COVID-19 seems to be on the receding platform, some of the hospitals are reporting no cases. The statistics are showing us that the virus is moving rather slowly. That doesn't mean that the virus has gone away. It doesn't mean at all that we're not going to get infected by the virus if we move into large crowds, and that we don't practice social distancing, hand sanitizing, masks. And of course, if you're feeling symptoms, now we're going into the winter period, and if you're feeling symptoms, it might be flu, it might not be COVID-19, but I would strongly suggest, and the Democratic Alliance has underlined this many times, please come forward, speak to your employer. Don't do it in person. Phone them. Tell them you've got the symptoms of COVID-19. It might be flu. Tell them that you're going to get a test. Tell them that you're going to take advice at the local clinic or your doctor or at a hospital. Do not arrive to work and pretend it's not there. It's very dangerous. And this case tells you all about it. It's an interesting case, and it's, as I said, a case that's just come out. In this particular case, an employee had contact with someone who was then found to have COVID-19, big positive. That employee decided to ignore that and tell no one and come to work. Obviously because he or she wanted to get paid, obviously because there were no symptoms at that point, and despite the fact that the employee knew that when you had come into contact with someone with COVID-19 that you should isolate and tell your employer, or if they got a medical committee, tell them that. And the Democratic Alliance has throughout this period of COVID-19 said, be responsible. Speak up. Let us know. Let your employer know what's going on. Do not keep it to yourself. Well, this employee did, came to work, and actually wasn't practicing any social distancing, wasn't wearing a mask, wasn't sanitizing his hands. Partially the employer's fault as well for not keeping an eye on this. But what did happen was, the employee then started feeling the symptoms, went for a test, all this time going to work every day, went for a test and got the result that he was positive. He still came back to work the next day to go and fetch some of his goods, and in fact hugged a fellow employee, not telling anyone that he's now positive. This eventually was found out by the employer. The employer then decided to take disciplinary action. That disciplinary action led to the dismissal of the employee, and I think quite rightly so. That employee then went to the Commission for Conciliation, Mediation and Arbitration, the CCMA. The CCMA said no, dismissal was unfair, but gave that person a final written warning and said that they can go back to work with no back pay. Company was unhappy, and they went on review to the Labour Court, which they could do, and rightly so. They went on review to the Labour Court. At the Labour Court, the judge took it extremely seriously, lambasted the CCMA commissioner, said that the commissioner didn't apply the law correctly, and said that what the employee did was reckless, absolutely reckless, had broken all the protocols of COVID-19, had put in danger not only himself but his fellow employees and customers, that the business he was working for it was a butchery and prepared meat and also cooked foods, and yet he was quite happy after he had seen that he had been with someone who was COVID positive to carry on coming to work, and even came to work on the day after he knew that he was positive. Well, the judge took it extremely seriously, overturned what the CCMA said, and then ordered the dismissal of that particular employee. The message that goes out in the judgment is an interesting one, and again I'm happy to email it to anyone who wants a copy. The judgment says that COVID-19 is still very much with us. The judgment says that COVID-19 has to be taken seriously, that you need to still practice social distancing, you need to practice hand sanitizing, you need to practice masks. It's the only thing that protects others from you and you from others. And of course, at the end of the day, the employer needs to ensure that that's properly put into place. So the message from the Democratic Alliance today, Sunday the 11th of April 2021, is that despite the fact that there is a few COVID-19 cases, not many, despite the fact that there are a few vaccines going around, also not many, and despite the fact that everyone seems to be now taking it less seriously, you must take it seriously. You must still take it seriously and practice what you need to do in terms of following all the COVID-19 protocols. So thank you once again for listening to me. It's Michael Bagram, Labour spokesperson for the Democratic Alliance, Sunday the 11th of April 2021. Thank you.